Great. Thanks so much. And thank you, everybody, for joining us today. I want to start with just a real brief story on a previous presentation that we made that was somewhat similar to this. We were submitting materials on fiduciary topics to a state SHRM conference. And we submitted the materials without any sort of title or heading to those. And much like a newspaper writer submits an article or a column and then somebody else assigns the title, we never quite know what we'll get in that scenario. So we submitted to the state SHRM conference, and it was a sports theme. And when they read through what we had put together, the title they gave it was Fiduciary Responsibilities, the Best Defense is a Strong Offense. And when we saw that, we thought that's absolutely perfect, because despite the topics being the types that a lot of times you see those and you think, well, this will be all about risk management, this will all be all about how frequently people are getting sued. To the contrary, the emphasis for us today in our discussion is how do you be a proactive fiduciary? How do you address these issues and these developments in the law, not merely because you're afraid of what a regulator will say, or not merely because you're going to be sued, but instead in the best interest of the employees who work for you. That is, how do you be those proactive fiduciaries and put into place a strong offense, which in turn will be your best defense. So that's the viewpoint we want to share with you today. And Scott and I collectively have a little bit of an interesting viewpoint for what we do. Scott's background is with building a 401k division within a firm and then essentially handling vendor relationships, fiduciary services, and participant education. And I'm an ERISA attorney, and so I came from experience in private legal practice and now use that compliance and fiduciary experience to work with Scott. And so combined, what we want to provide for you today is a practical way of looking at the regulations, of looking at litigation, and of looking at this need to benchmark and say, practically speaking, how do we do this and how do we do this well? So here's our roadmap for today. As you can tell from the title, we want to start with the fiduciary regulation and really say for you, what do you need to know? Because there's a lot of information out there regarding the fiduciary regulation, but not all of it applies directly to you as plan sponsors. Then we want to pivot and talk about some lessons we can learn from litigation, where we can not only look at what the risks are, but say, how do we look at those and develop best practices that you can then implement for your plans? And then finally, the fiduciary regulation, these lessons from litigation, they suggest to us that benchmarking is becoming more and more important and more prevalent. So let's talk a little bit about why we do that and then also how we do it. Now, we have a polling capability with this presentation, and from time to time we want to raise some questions with you. And right now, we want to start with this question, and we invite you all to read it and choose the answer that you think is most correct. Which of the following are fiduciary duties under ERISA? Is it the duty to use the cheapest fund, to protect your fiduciaries? Is it the duties of prudence and loyalty, or is it the duty to mitigate fiduciaries' risk? Take a second here, read those answers, and choose the one that you believe to be most appropriate and most correct. Okay, let's flip to the next slide, and what we can see here is that the people who ended with loyalty and prudence got it right. In fact, I saw one answer that started somewhere else and ended in the right place. And this is all really important because we need to understand the context and the background of your fiduciary responsibilities. When the courts say that a fiduciary's duties are the highest known to law, we should recognize that as fairly significant. And then when we look at what these specific responsibilities are, this duty of loyalty and the duty of prudence should stand out for everything you're doing as fiduciaries. And I applaud you for not saying the number one duty of a fiduciary is to mitigate his or her risk. And it's not to pick the cheapest investment funds. Instead, it's to make decisions in the best interests of participants. It's instead to exercise the care and the skill, the diligence and the prudence of someone familiar with the matters. Those are core responsibilities, and as I noted before, when you keep those in mind, it allows you to truly become that proactive and better defended fiduciary. So here's what we went through, and remember, we're talking first and foremost here about this new fiduciary regulation. So we've gone through, over the last year, significant battles between special interests and the Department of Labor. So in 2010, the Department of Labor said, we believe the definition of fiduciary is far too narrow. You know, it hadn't been changed since it was enacted in 1975. And so in 2010, the Department of Labor said so much has changed since then, so we need to expand its reach. And they put out the publication, the proposed regulation in 2010, went through hours and hours and hours of testimony and thousands of pages of comments, and realized that there was a lot of pushback out there in the financial services industry. So they took a step back and said, we need to look at this again. And in 2015, the Department of Labor proposed a new regulation where they said, we've listened to you. We have a new regulation that focuses more clearly on conflicts of interest, and here's our proposal. So in 2015, the financial services industry sees that and says, oh my gosh, this will cripple our business. And so as the financial services industry pushed harder and harder against the Department of Labor, here's what they said. They said to the Department of Labor, you cannot do this to us, because if you do, we can't make the high margins that we've been making from employees, from American workers, from plan participants. And the Department of Labor said that's exactly why we need an expanded definition of fiduciary. They said participants' interests outweigh the conflicts of interest. And that's what led the Department of Labor earlier this year to publish a final regulation that redefines and expands the definition of fiduciary. And this is another reason that this was so important, is the Department of Labor started diving into this and saying, you know, we have a national retirement crisis ahead of us. We have employees who are basing most of their future ability to retire on money that they have in defined contribution plans, and actually even more in IRAs than that, and less in pension plans. Are they getting the types of protections that they need? And what they also noted, and you probably are familiar with this if you've been in the marketplace for a while, we've moved over the last 40 years from a defined benefit plan culture to a defined contribution plan culture. And more specifically, we've moved from a structure in which employees had very few decisions to make. Think about when a worker came to work in 1975 or 1980 or even 1985. Did that individual need to decide whether to participate in a plan, and how much to save, and what investments to choose, and when to save more? And then when that employee went to retire, did he or she have to figure out, how do I get an annuity that will make my savings last for my lifetime? Well, no, that wasn't the case. But now all those decisions sit in the hands of the participants. We know they have to make those choices. And the Department of Labor said, oh my gosh, not only are they making bad choices, but they're getting bad advice when they ask people for support. And here was the biggest concern from the Department of Labor's perspective. They're getting advice from people who are not fiduciaries. Remember that quote earlier that says that a fiduciary duty is the highest duty known to law? Well, the Department of Labor said, you know what? When you're working with a non-fiduciary, we have two problems right there. Number one, that individual does not have the highest duty known to law. That is, that individual does not need to put the client's interests first, but instead that non-fiduciary can put the non-fiduciary's interests first. And we can all see why that's a problem. But then there's this extra layer, this second layer that really concerned the Department of Labor, and that was this fact. If they're not fiduciaries and things go wrong, they don't have the same level of culpability to try to make things right. And we've seen that all throughout litigation and even in Department of Labor pursuits and investigations. When you have non-fiduciaries working in a capacity where you would think they would be fiduciaries, they get to escape unscathed when things go wrong. So the Department of Labor said a stronger fiduciary standard is necessary. That's the only way we can protect Americans' interests. And so in this final regulation, that's what they sought to accomplish. And so as I mentioned earlier, now we're getting to the part that really tells you what you need to take away from this. it expands the definition of fiduciary. And the way it does that is both in terms of actors and context. And what do we mean by that? We mean, first and foremost, it takes individuals who previously were not fiduciaries. In fact, they went out of their way to not be fiduciaries. And the new regulation says you will become a fiduciary if you keep doing what you're doing. So that's a big change. All of a sudden, we have this whole new class of fiduciaries. Then, separately, I said it changes in terms of context. That means that you have individuals who have been providing advice, who have been providing recommendations regarding whether to take a rollover, whether to take a distribution, whether to not take a rollover, whether to not take a distribution, what to buy with that rollover, where to roll it, what IRA to choose, what platform to use, what investments to hold. All of those, guess what? Those will now become fiduciary recommendations. As you hear that, you can probably think to yourself, wow, that's really good for American workers. And wow, I can see why financial advisors, many of them, would be very nervous, would be very uneasy and very nervous about this. Because the result of all this is really a consumer protection structure. Your employees will have better protections as a result. So what steps do you need to take as a plan sponsor? And if you're taking notes, this is where you start to note the things that you'll need to ask to make sure that you're ready for this regulation. Now, there are special rules for plans under $50 million. If your plan is under $50 million, the individual or the individuals or the company that provides you your investment support will have to do that as a fiduciary. And if they want to continue to be paid via commissions or through revenue sharing, as many of them have been in the past, and that's particularly the case if you're on a group annuity contract platform, like say Transamerica, One America, Principal, Mass Mutual, companies like that, if that's the case, they're going to have a hard time keeping their prior business structure. So what will happen, I predict, is that for your plans under $50 million, if you've been paying somebody on a commission basis or revenue sharing basis, they're going to look to change that to where they give you a very clear price quote. They say, I will do your work for 0.25%, 25 basis points, 0.25%. Or they'll say, I will do your work for $35,000 per year, something like that. Now, if your plan's over $50 million, technically speaking, your advisor, your broker, your consultant doesn't have to be a fiduciary. There is a carve-out available, but that carve-out would require your provider to disclose to you that he or she is not undertaking to provide impartial investment advice. That is, they actually have to say to you, hey, you've hired me and I don't have to be impartial. That's the only way they can be a non-fiduciary. So what do you think will happen there? I think it's pretty safe for us to assume that they will also move to become fiduciaries. So here are the questions that I would recommend my clients ask their broker or their advisor or their consultant. Number one, are you a fiduciary? Simple question, yes, no answer. Number two, if you said yes, where have you said so in writing? Needs to be in writing, none of this fudging, none of this, well, I am orally, but I can't give you that in writing. It's going to be a yes, no answer, both orally and on paper. And then third, what do we do now if the answer is no to either of those questions? What do we do when we're working with somebody? It might be somebody we like very much. It might be somebody with whom we have a long-standing relationship. But if that individual can't become a fiduciary or refuses to or still isn't sure, what do we do now? So that's one part from a plan level perspective, the process for you to go through in interacting with your broker or your advisor. Now, I mentioned earlier that all of these recommendations relating to distributions and rollovers are going to become fiduciary advice steps. And that's a really big deal, and that should provide some additional protections to your participants. And as I said before, it's very broad. You can see from this slide here, it covers whether to take the rollover or the distribution, in what amount to take the distribution, in what form to take the distribution, to what destination. That is very, very broad. So for you, these are the 5 takeaways for plan sponsors from this fiduciary regulation. Number one, there's a brighter spotlight on the term fiduciary. The Department of Labor said over and over and over again in all of the guidance that it released, just how important it is and significant it is to have a fiduciary. So those 3 steps that I gave you, it's time to walk through those 3 steps and make sure you know whether your broker or your advisor is serving in a fiduciary capacity, and if not, what to do now. Because number 2 on this list is to take note of the delayed effective date. It's hard for non-fiduciaries to change their business practice, their business model, to suddenly become fiduciaries. You can probably think about many of those providers who have spent so much time going out of their way making sure that they are not a fiduciary and now trying to decide within a year whether they can become one. So the Department of Labor said, you know what, we'll give you about a year to figure this out, but that's it. You've got to know. Well, here we are already halfway through that original year. We're almost to April of 2017. So what do you do if you don't have a fiduciary right now? How do you handle that? I think that's a real tough question for plan sponsors. What do we do? Because the Department of Labor has said our current structure exposes us to risk. Our current structure is insufficient to protect our employees. So I think that really means for you as plan sponsors, you want to be very assertive dealing with your current providers. And as we'll talk later, that's why we get into this time where benchmarking is becoming more and more prevalent. Now, number 3, this is really important for your fiduciaries to understand. We're going to have a whole new class of fiduciaries who are affiliated with retirement plans. So do you know what that means for your current fiduciaries? It means they become what is called a co-fiduciary with these new fiduciaries. Co-fiduciary liability means if you are a fiduciary and you have reason to know or actual knowledge that another fiduciary is breaching its responsibilities, then the co-fiduciary can be liable as well. In other words, you kind of have to be aware of what your other fiduciaries are doing. Also, your fiduciaries have an ongoing duty to monitor all of your providers. That means you have to start looking into what sorts of advice your brokers are providing, your advisor is providing, your record keeper call center. Have you ever looked at a terminated employee packet from your record keeper? You ever looked at one of those that might even have a little green arrow on it? It tells them where the money should go when they leave. That will become important for your committee to either on their own somehow get a hold of call center scripts and understand what they're saying in those call centers, or to somehow make sure that you can get the paperwork modified, or to make sure that you have a fiduciary advisor who's taking on those tasks for you. So keep that in mind. This co-fiduciary liability is truly a trap for the unwary for many plan sponsors. Now the next step is these group annuity contract platforms. I mentioned this earlier. Those will be terribly difficult for brokers to continue to offer. So that's yet another instance, and I apologize for the recurring theme here, but another instance where you say, you know what, the marketplace has changed so much, these plans will need to be benchmarked. And then the 5th takeaway for you, if you're using a record keeper solution model portfolio, you need to be aware of what the new regulation says. And what do I mean by a record keeper solution model portfolio? What I really mean there is you've picked your core funds list. You've either done it on your own or you've used an advisor or a fiduciary to help you. But you've said, you know what, I want 5, 7, 9, 11 risk-based models on my plan. And you know what, if you just make those up of the funds that are in my core funds list, we'll be good. Well, we got a reminder from the Department of Labor that says you need to keep an eye on those. You need to monitor those. You need to monitor the allocations. You also need to make sure that the funds that are being used were chosen in an unbiased manner. So if you're using one of these record keeper solution portfolios like Goalmaker with Prudential, like Portfolio Express or Custom Portfolios with Transamerica, like Custom Choice with Mass Mutual, like Strategic Advisors through Fidelity, you need to know those component funds that are being used, especially your stable value fund. Your fiduciaries either need to monitor and make sure that fund was chosen in an unbiased manner, or that you're using a fiduciary who has said, we'll take that responsibility for you. Those are your key takeaways for your plan sponsors. So that's a breakdown of what I think you need to know. And of course, as you can probably imagine, we could spend hours on this new fiduciary regulation. There's a lot here. But the best question for you is, as a plan sponsor, what do I need to know? And I think these takeaways right here really tell you what you need to know. So let's pivot now, as I said before. Let's move from exploring the impact of the fiduciary regulation, and let's talk about all this litigation. And as I promised you up front, the focal point for our discussion today is not to say you are going to get sued. That's not the point of this. In fact, statistically, it's not very likely at all that you'll get sued. However, it is statistically likely that you're leaving money on the table for your participants by not being aware of these sorts of issues. So let's walk through some of these cases, look at some best practices, and say, how can you improve your plan by learning from what these other poor, unfortunate plan sponsors are enduring? And when we do that, we're going to think about the ongoing nature of your fiduciary responsibilities, making sure that you know what sort of education and what questions you have to ask, and understanding share classes. In fact, let's start off with a poll question, and I'd like each of you to read this and to provide the answer that you think is most appropriate. With respect to share classes, which of these is the right answer for you? We have not conducted a review. We use some retail shares. We've moved to all the cheapest share classes, or we could use more education on this. In fact, if you aren't familiar with that term or you haven't talked about it, choose that last answer. We could use more education on this if that's the right approach for you. And I'll give you a second here to fill in some of these. The nice thing here is there's no right answer to this. This is truly about your particular experience. So we can see from the results we're getting a mix here where some of you are saying, you know what, we use retail shares, and some are saying we could use more education, and only 1 out of about 10 here has said we've moved to all the cheapest. So let's talk about share classes, because I think my initial reaction, if I would have seen this a couple of years ago, would have been, what are you talking about? I don't even know how to answer this question because I don't even know what that term means. Well, we had a lawsuit that really got into this. And it was a big lawsuit out in California, and it was a plan that was over $2 billion, actually close to $3 billion. And here's what they did. They used what's called a retail share class lineup. That is, they failed to exert the leverage of that plan size to buy cheaper versions of the mutual funds they were using. Did you know that there are cheaper versions of many mutual funds than what many of you are using? And here's how that developed. Let's pretend 20 years ago you had $50,000 and you walked down the street with it to your local broker and you said, I want to buy that mutual fund. They'd say, okay, we'll take your $50,000, you can buy the fund, but you know what? That's not a lot of money, so we're going to charge you quite a bit for that. You said, well, that's fine. That's all I've got. That's what I'll buy. So a couple months later, a successful friend of yours says, you know what? I want to buy that mutual fund. I've got $250,000. I've got more money. I want to buy it, but I have more leverage. And the fund company said, you know what? We want to sell it to you, and we want your money, so we'll set up a new share class. We'll give you the exact same fund, but we'll charge you a little less. Well, then suddenly somebody with $500,000 came along, and then somebody with $1 million, and then you had a retirement plan with $2 or $3 million, and then one with 10, and one with 50, and so forth. And you can see how that would happen. The more money you have, the more you are like an institutional investor. That is, you have institutional buying power. Whereas when you have less money, you're a retail investor. You don't have that bargaining power. So these fund companies set up multiple share classes. It's the exact same fund, and the only difference is the expense ratio. And how do we know what you're using? We look at the end of the name of the fund. We look at capital letters. We look at 3-letter abbreviations, and we can tell what you're using. So here's what happened in this case. They were using retail share class funds. They didn't ask the question, say, hey, can we use the cheaper version? And a plaintiff's attorney got a hold of that and said, whoa, this is messed up. You absolutely cannot fail to exert your leverage on a plan of this size. So then it went to the Supreme Court eventually, and they asked the Supreme Court to say, okay, Supreme Court, it's been settled at the lower courts that this plan sponsor messed up. This committee needed to use institutional share class funds. But the question now is, how far back can they be liable? Are you familiar with the term statute of limitations? That really means that you can't be liable forever for everything. In this case, it's 6 years. In other words, You can't be liable for bad things that happened more than 6 years ago. So some of these funds were put in 8 years ago, 9 years ago, 10 years ago. So when I went to the Supreme Court, here's what the plan sponsor said. Okay, we don't agree. We don't think we should be liable. We don't think we did anything wrong. But if we are wrong, we're only wrong for the expensive funds we put in the last 6 years. If we put an expensive fund in 9 years ago, we can't be liable for that. And so the question in front of the Supreme Court was, do your fiduciaries have an ongoing duty to look at their funds? And the Supreme Court said, as you can imagine, yes, they do. Your fiduciaries have a responsibility. If you put an expensive fund in 9 years ago, you're not liable for that 9 years ago. And you're not liable 8 years ago, and you're not liable 7 years ago. But 6 years ago, you decided to keep that. And then 5.5 years ago, you kept it, and so forth. You're liable for everything within that statute of limitations because your fiduciaries have a continuing duty to look at their investments. So here are the best practices that you can take away from this. That is, how can you proactively avoid the sort of responsibility and liability that came up in this particular case? Well, number one is to utilize a fiduciary investment manager. In the case I just referenced, when the committee and the plan sponsor went to court, they said, hey, we've got a consultant. We have a broker who does this for us. And the court said in its opinion, that's a consultant, not a fiduciary. So the consultant in that case was dismissed from the lawsuit and not held liable at all. You have the ability to shift the responsibility for choosing funds from your committee to an investment manager, a fiduciary. And when you do that, Section 338 of ERISA says that they will take the responsibility for that particular decision. Now, a second best practice for you to keep in mind is it's important for you to make sure you're using the cheapest share class. And that's really where we started off this conversation. Do you remember me saying just how easy it is to figure out whether you're using an expensive share? You truly can go to your Form 5500, which is filed with the Department of Labor. We could pull it up on the internet right now. We could look at the audit report, assuming that your plan's over 100 participants and you have an audit report. We can look at the names of your funds and we could tell whether your funds were too expensive. That is, whether you're using those expensive share classes. Well, that's a big deal when you figure out that a Department of Labor investigator or a plaintiff's attorney could do that so easily. That's something you want to work on fixing. A third best practice is to make sure you've got consistent processes in place. Can you demonstrate that you have an investment policy statement? Do you have minutes that say, we have an investment policy statement, these are the reports we got, this is what we do on a semi-annual or a quarterly basis? And finally, are you able to ensure that when you do that, when you go through that process, you have a system for considering what you do? You have some sort of criteria or some sort of standards to which they have to live up to. Those are the best practices for you to take from probably the most significant 401k litigation case that I can recall. Certainly got the most attention, got the Supreme Court's attention. Now here's a separate case, and this one's a pretty easy lesson for you to learn. You want to know who your fiduciaries are. Here's what happened here. Plan sponsor enters into a deal with a record keeper. It's on what's called a group annuity contract platform. It was a fairly small plan, and they said, you know what, we don't want to hire a fiduciary, we want to do this on our own. So they went to principal and they said, hey, principal, we want you to set up this plan for us. We want you to give us a fund lineup, a platform that we can choose our funds from. Well, the plan sponsor eventually realized that those are ridiculously expensive and said, oh my gosh, we entered into a bad deal. What do we do now? And what they decided to do was to file a suit against the record keeper. So they said in this case, we allege that our record keeper breached its fiduciary responsibilities. And you know how it did that? Well, it gave us a limited platform to start with. Then it narrowed that platform, and now they're charging us way too much for what they do. Sounds like a pretty good lawsuit, doesn't it? What do you think the court said? The court kind of laughed, said, you know what? Principal's not a fiduciary. Your record keeper isn't a fiduciary regarding the platform. You picked them. That's on you. So you chose that limited platform, and you, plan sponsor, narrowed those funds, and you, plan sponsor, agreed to pay too much. You entered into a bad deal. You can't shift that responsibility to the record keeper. So here's your takeaway. These are your best practices from this case. Number one, it's important to identify who your fiduciaries are. Who are they? Who are not fiduciaries? That is, who's not subject to a fiduciary responsibility? This is really important for you. Let's say you use a record keeper, and you had a bunch of those record keepers' funds in your plan, and they give you some investment reporting information on a quarterly or a semi-annual basis. It's important for you to know that they don't have an obligation to be unbiased. They don't have an obligation to give you access to other funds. They're not your fiduciary. And then once you identify who the fiduciaries are, you want to be able to know what their responsibilities are and what their authority is. And so if you can walk through and say, who are my fiduciaries and what are they in charge of and what can they and what must they do, those are the steps for you to, again, be proactive and to protect your fiduciaries. Now here's a different line of cases where I think some lessons are really easy for you to learn and to pick up on here. There's a plaintiff's firm out of St. Louis that's been incredibly successful filing lawsuits in 401k plans. They're really good at what they do. And they recently filed separate lawsuits against plans that use Vanguard funds. And more specifically, they not only use the funds, but they use Vanguard's record-keeping system. Now, that was pretty interesting for us because if you go back to a lot of the other litigation, you'd look at the funds that were held up as the example for cheap funds, and what do you think those firms used? They used Vanguard. In all the other litigation, they said, you were using XYZ company, you should have used Vanguard. But in this situation, they didn't. In this situation, they said, you are using Vanguard funds, and those Vanguard funds are too expensive. Now, these are pretty large plans, and these are situations where the plaintiffs have already run into some challenges. In fact, one of these cases was primarily, or most of it's been dismissed by the district court, who said, you got to do better with your pleading. What you've alleged right now is not enough. But nonetheless, when we read through these pleadings, we say to you, hey, there's some lessons for you to be able to take away from this. There are some things for you to go back and make sure you do with your plans and your committee to protect your participants' interests. We've already talked about exploring the cheapest share class available. That's the first one here. But next is, especially if your plan's larger, if you've got a plan that's north of $100 million or so, and actually that number is creeping lower and lower, have you looked into whether you can use what's called a separate account or a collective investment trust? This push toward using collective investment trusts is really all the rage for plans across the entire country. It's no longer good enough, perhaps, to use an S&P 500 index mutual fund that costs 0.05% if there's a collective trust version that costs 0.02%. Doesn't that sound silly? Doesn't that sound silly that over 0.03%, so 1/33 of 1%, but yet in cases like this, and the bigger your plan gets, the bigger those dollars are and the more that it impacts your employees' bottom lines within their plans. It's also important for you to look at the expense structure of active funds and passive funds. The fact of the matter is, passive funds or index funds have had a really good run lately. And if you've looked at any of your reporting information, you can say, like, wow, why are we choosing these active funds when they're underperforming but costing more? And these complaints, what they say is they don't even get into performance. They just say you paid too much and you don't have any reason to back it up. That's an important step for you. And then we'll talk more about the benchmarking later. Now I have a polling question for you here before we jump into this next suit. And this relates to a lawsuit that was filed just within the last month. And it relates to target date funds. And here's the question. With respect to target date funds, which of these is the most appropriate answer? A, we've undertaken a thorough review of ours. B, we have considered those that are managed by somebody other than our record keeper. The next answer is, well, both. We've done those. The fourth answer is, well, neither. We haven't looked at ours really, and we actually haven't considered those that aren't run by our record keeper. And then the final question is, well, we don't use target date funds. Which of those is most applicable to you? Okay, we're going to close the voting on this, and I appreciate the feedback because the responses we got here tells us that you as a group have done a better job than what people have done across the entire country. Because what we see across the country is that plan sponsors have not paid enough attention to that fact. And so let's look at this recent lawsuit and then think, what can you take away from that? A lawsuit filed against the plan sponsor Safeway Inc., big grocery store chain that many of you have probably heard of. Here's what happened in that case. That plan was using BlackRock's target date funds, but using JP Morgan for record-keeping services. And in 2011, JP Morgan came to them and said, hey, we'd like you to start using our target date funds. And we're going to build in some revenue sharing here. In other words, we're going to have about 20 basis points or 0.20% of fat built into these, and we'll rebate that to the plan, and that'll pay for the record-keeping expenses. And that'll be a good thing because then your employees will think they don't have to pay anything. Okay, well, that's pretty interesting because here's what happened. Those target date fund assets over the course of about 3.5 years doubled, yet the total participant count went down. So what does that mean? That means the revenue coming for those to the record keeper doubled, yet the record keeper's workload actually fell during that period of time. So the lawsuit that's filed here is really fascinating because they did a really good job of saying, wait a minute, you didn't even look at whether this move to the record keeper's target date funds made sense. So what we take away from this is, number one, you want to utilize an independent fiduciary to select and monitor your target date funds. The record keeper that has target date funds, remember, they're not a fiduciary. This is not a non-for-profit world, is it? Right? They have the right to try to make money. So they're going to try to recommend, on average, that you use their funds when you can. So as a result of that, number two on this list is you want to make sure that you consider non-proprietary target date funds. And then finally, have you documented a process? Can you show that you've looked at your target date funds and you can justify why you use what you use? The fourth point on this is a big one. One of the big problems with this case is they didn't have a clearly negotiated record-keeping fee. In essence, the way it worked is that all the excess revenue that came in, the record keeper got to keep that money. It is vitally important for you to say the best way to protect our employees is to make sure we know what our record-keeping expenses are so that those don't run away as our plan grows. And that's why you need to do what the fifth step says here, and that is to evolve from depending on revenue sharing. The time for that's past. That was back when there wasn't full disclosure of fees and expenses and so forth. We're in an era of transparency right now where you need to know what you're going to pay. You need to bargain and exert your leverage to get that fixed and then clearly communicate it to your employees. Now, I understand I have a question, and I apologize because it didn't pop up on my screen, but colleagues have said that it's been here for a while, so I apologize for the delay, but it's relevant here. We'll answer it here. The question was, would you not recommend a 321 in lieu of a 338? Now, some of you probably know what those numbers mean, and others are saying, how do we answer that without knowing what those numbers are? So I'll describe those. Section 321 of ERISA says to us, you can hire a fiduciary. A fiduciary is somebody who provides investment recommendations for a fee. So if you hire somebody under 321, you pay them, or your plan pays them, or your participants pay them to give you advice. But they don't make decisions. They don't have the ultimate decision-making responsibility. Section 338 of ERISA is different. Section 338 says you can do what you did under 321, and you can shift to that investment provider the responsibility to select funds, to monitor the funds, and to make changes. So if participants later complain or plaintiffs' attorneys later complain and they say, hey, you used the wrong share class. Hey, you used active funds when you could have used cheaper passive funds. Hey, you used proprietary funds when you could have used non-proprietary funds. If you hire a 321, those decisions will be on you as the plan sponsor. And that investment advisor of yours will drop out of that lawsuit. If you hire a 338, those responsibilities move over to the 338. So what I tell my clients when I perform legal services is the following. It used to be expensive to hire a 338. It's not that expensive anymore. So I want you to hire a 338 for the following reasons. Number one, you actually get to shift tasks. You actually literally get to shift tasks and responsibilities, and that's good, so my clients can go about their day jobs. Number two, You move that to somebody who says, we'll take those tasks and we'll do it as a fiduciary, which means they have skin in the game. And number three, you've moved it to a professional. The statute actually requires that an investment manager meet certain statutory requirements, and that's what you accomplish by doing that. So I hope that answers the question. 321 is helpful because you have a fiduciary. The Department of Labor spoke at length about that, but 338 gives you more bang for your buck. All right, we're going to shift now to the final section, and this is where we move past regulation for the most part and past litigation for the most part, and let's talk about real practical solutions to help out your human resources department, to help out your company's bottom line, to help out your employees. And I want to start with something different than 401k plans. I want to ask you about your health insurance shopping process. So I imagine many of you are connected to or you're familiar with your health insurance process. And I'm curious, when it's time for you to renegotiate your premiums, do you go to your current insurance carrier and say, hey, Blue Cross Blue Shield, hey, Aetna, hey, United Healthcare, hey, Wellmark, are we paying the national average? Is that the approach you take? Or do you go out to the marketplace and you say, I want some competitive bids and proposals for what we can do? Now, a slightly different question. When you're shopping for health insurance, do you say, I just want a price? Or do you dig deeper and say, I need to see premium quotes, I need to know a high deductible option, a low deductible option, I need to know what our co-pays are, I need to know out-of-pocket maximum, I need to know family out-of-pocket maximums, I need to know what our deductible is in particular, I need to know whether you pay claims well, and I need to know the size of your network, I need to know your drug benefits. Think of all those details you get into, don't you? And then, this is the real kicker. Do you wait 5, 10, 20 years to look at your health insurance premiums? Do any of you do that? It seems pretty absurd, doesn't it? You know, when we stop and think about it, we say, oh my gosh, what kind of employer would even go 3 years right now, let alone 5 years, 10 years, or 20 years? So I've got a poll question for you as we shift. Here's the question. When did you last benchmark your 401k, your 403b, or your 457 plan, your primary defined contribution plan? When did you last have an outside party? That's the key. When did you last have an outside party perform that? Was it within the last year, the last 1 to 3, the last 3 to 5? Has it been more than 5, or are you not sure? I think this is critically important to remember. It's an outside party because I know it's really easy to go to your current record keeper and for them to come back with a report that says, hey, your fees are within the national average. But the real question is, are you using an outside party and are you getting real feedback? All right, we'll close the voting on that, and I appreciate those of you who responded. I see, you know, a strong group of you said we've done it within the last 1 to 3 years, and a big group said, you know, I'm not really sure. And that's pretty common to say, you know, I'm not exactly sure when we did it last. But here's the question I raise. Why is it so different for 401k plans? I've wondered about this quite a bit, and I've talked with human resource professionals, and I say, why don't you do it more often? And you know what I hear, and I guess this makes sense. Well, because it's a pain to move. It's just a lot of work if I have to move the plan. And, you know, I get that. It makes a lot of sense. And so then I thought, okay, what would happen during your benchmarking process that would lead you to make a change? Why would you even need to make a change? And somebody in HR will think about that and say, well, if I found something better. I said, okay, so what I want you to do here is I want you to be able to tell your employees, I want you to say, the reason we don't look at this is because we think we're going to find something better for you, and that's a lot of work that we'd have to do to go out and get that for you. But that's really what it all boils down to, is it feels like a lot of work. And so when I think about benchmarking, I don't think about how do I move the plan. I think about benchmarking like this. How do I hold my current provider's feet to the fire? How do I make sure that I've got the right pricing level, the right service level, or both? And so as you think about a record-keeping benchmarking or an advisor benchmarking exercise, think about it from that perspective. Not thinking, hey, we're going to have to move this thing, but instead, I need to do better for my employees. So what we want to share with you here pretty quickly is just saying, why do you benchmark? And then how do you benchmark? And the reason I say why do you benchmark is I've seen a lot of times, whether you're a CFO or you're an HR professional or you have some other role within your organization, you can have in your own mind reasons that you want to move, or more broadly, reasons that you just want to look at this. And it's hard to communicate that to others within your organization. So we hope we can give you 4 reasons here where at least one of those will strike a chord with the people who you work with. You know, you've decided this is the right thing to do, but you need to figure out for the other decision makers, what are the salient points that will cause them to want to go along with you. So here's the first one. Number 1 reason you do it, because regulations require that you do it. These regulations under Section 408B2 became effective in 2012. And they say you need to know what you pay, you need to know what services you're getting, and you need to be able to demonstrate that you're paying no more than what is reasonable. That means you have to have some documentation that shows your process. So that's why you go through a benchmarking exercise, because if you're ever asked by the Department of Labor, do you have your disclosures? You'd say, yes, I do. Do you know what you pay? Yes, I do. How do you know that's reasonable? Oh, I have this benchmarking report right here. This is the exercise we went through. Here's the RFP that we ran. That's how you get to that point. So that's one reason. Another reason is that the federal courts say you ought to do this every 3 years or so. That's pretty simple. Courts have looked at this and they, you know what, they quote each other, they cite each other all across the country, and they say you need to be kicking the tires on this every 3 years. That doesn't mean you need a full-blown RFP, but you really should be doing some marketplace benchmarking due diligence. That's what you have to do. So number 2, the federal courts say to do it. Number 3, why do you do it? Well, there's been so many rapid changes in the marketplace, and you've probably seen this, that since the Form 5500 Schedule C started to include so much more information, and then you started getting all this information in your disclosures and the disclosures that go to participants, think about how much more information there is. So things have become more transparent, which has driven down prices, which has made the marketplace more competitive. And so all of these record keepers out there are scrambling to gather assets, to gather clients, and the only way they do that is to develop new tools. So I really mean this. When it comes to record keeping, you can get so much more for so much less now than you could even 3, 4, 5 years ago. That's the 3rd reason. Number 4 reason, you care about your employees. Really. I mean, let's think about those core fiduciary responsibilities under ERISA. You want to make decisions in their best interests. And so wouldn't you like to be able to say to your employees, we've done right by you. We've done everything we can, and that's the 4th reason to do it. So that's kind of why you do it. Let's talk about how you do it, because I think there are 3 distinct ways you can do it, and we'll talk about the benefits and the detriments of those. So 3 basic types of benchmarking. One is to just utilize industry averages. Second is to use a third-party service, and the third is actually to go to market. Now, what do those mean? Well, let's expand on each of those just a little bit. Utilization of industry averages. That means you pull together you use a book like the book of 401k averages that pulls data from 5500s or pulls data from one specific record keeper and says, here you go, here's how you benchmark. And that can be kind of nice because it's easy to document, it's pretty cheap. But the downside is it's using stale data, it overstates average fees because it doesn't know how to account for record keeping or for revenue sharing. So you don't really get a feel for whether you're paying a very good price. It'll help you check the box though, but as you can see here in just a little bit, it doesn't get you to the same result for your people. Now how about third-party services? There's a popular website called fiduciarybenchmarks.com. That website does a better job of pulling in more data. And you can pay a small amount, or you can have an advisor pay a small amount to go out and look at this, and it can be kind of nice. You get a nice looking report, and it shows that you've maybe expended a little bit of money and a little bit of time, and you can probably realize some savings as a result. Now, the downside is the better the service, the more expensive it is, and it actually typically results in a markup on the services that are provided to third parties. That is, again, it overstates what the expenses are out in the marketplace, which makes your pricing structure look better than it really is. Now, the third approach is kind of like what you do in health insurance. Remember the question I raised there? How many of you go to your current provider and say, what's the national average, and am I paying something in line with that? Instead, with your 401k plan, you go to market, and you say, I want bids. I want people who want my business, who will compete for my business and will give me specific quotes that apply to what I do. That's going to be the best result for your fiduciaries and for your employees. And I have a case study here that will help you to see how that's the case. So we took a client, we won't share the name, but just want to tell you how these different results apply, or the different approaches apply, and what gives you the best result. So this is total plan assets of about $111 million, about 20 locations, about 2,400 participants. And we said, what result do we get if we benchmark this plan using the three approaches we just described? So first we started with the 401k averages book, and we put in the closest numbers we could, and we said if we bundle all this together, what's the cost look like? And the output, 0.87% all in, a little less than 1%. Remember that number, 0.87. Then we said, okay, now let's go to this next step. Let's use this fiduciary benchmarks program. Went through a pretty similar exercise, got a number, 0.83%. A little bit better, isn't it? A little bit better data, probably a slightly better result, and both of these steps probably help the fiduciaries to say we can check the box, we can say we did this. Then we went to market, and we went to some of the biggest record keepers in the country, and we said, hey, Fidelity, Empower, that used to be JP Morgan, Prudential, Mass Mutual, Transamerica, we want your bids. We want you to fight for this business. And oh my gosh, was there a dramatic difference in what we saw. We saw the average total bundled expense, which even include investment management expenses, down at 41 basis points. Remember the numbers I showed you before? 87, 83, 41. What a great deal for the employees in that plan to benefit from that thoughtful process that the fiduciaries went through. Now here's another example. I mentioned earlier that record keepers aren't fiduciaries, so they're probably not the best sources for this type of information. The lesson here is to not rely on the record keeper for exactly what you want. This is a plan that used principal as the record keeper. They had a very long relationship. And in April of 2015, they were charging 28 basis points. That's 0.28%. The record keeper found out that they were going to do an advisor RFP, and they went to the client and said, we appreciate your business so much. We're going to drop it from 28 to 23. So after the advisor was engaged, we ran an RFP process, and we said, we want the record keepers to fight for the business. Do you know what principal's first price was? 11. They later dropped it to 10 and eventually to 7. So when they went straight to the record keeper said, we value our 15-year relationship so much that we will drop our price by 18%. But when there were market pressures, they would drop the price by 300%. That's what happens when you try to rely upon just the record keeper. Now here's another example, and I don't have a slide on this, but I'm thinking of a plan that's twice the size of this plan, even bigger than that. And they've been using their record keeper for an extensive period of time. And that current provider said, you know what, we'll go from 32 basis points to 24 because we value the business. As a result of a record keeper RFP, they ended up at 8. That's pretty similar to the numbers we shared here. The record keeper's original adjustment was 25%, and the ultimate outcome was a 300% reduction. But that's what happens. Think about just the additional pressure you face when your feet are truly being held to the fire. So as a reminder, there's really 4 reasons why you do it. The regulations say you need to show you know your fees are reasonable. The courts say you need to do it every 3 years. The marketplace has changed so quickly, and it's a great way to demonstrate care for your employees. By utilizing open market competition and thinking about that health insurance approach, that's how you get to a better result. So how do you take all this, and this is really my last slide here for you, how do you be that proactive fiduciary? How do you say the best defense is a strong offense? Well, you go out and you say these best practices that we talked about today, we're going to put those into place. We're going to ask the right questions and take advantage of the open market benchmarking and the current price pressures to get more for less for our people. And when this fiduciary regulation kicks in, we're going to embrace that and say this is good for our people. Sure, it might expand our responsibilities as plan sponsors, but if we're informed, we can handle that. And if we're informed, we'll move toward a more transparent pricing structure. And the reason we're doing all that is not just to CYA, although that's a nice benefit. And that might be very important within your organization, but the main reason we're doing that is because we want the best results for our employees. You might remember this quote from earlier. Having your investment advisor be a fiduciary is important because it means they're required to give you advice that's in your best interest, not their own. That's the new fiduciary world that we're living in, is the emphasis on the importance of having a fiduciary. And I hope our talk today has given you enough ammunition to understand where there's room for improvement for the plans and how you can go about realizing that improvement. That's the end of our presentation for today. We'll watch for just a little bit, see if we have any questions in the last minute or two here at the bottom of the screen. And if not, I'll turn it over to you, Kelly, to wrap up.
Thank you, Matthew. That was definitely an excellent presentation. I really appreciate your time today, and I appreciate the audience's time. We do have one question that has come in. Does the litigation only involve mega plans, or are smaller plans also a target?
Oh, yeah, that's a good question. You know, until about 4 or 5 months ago, it looked like just the mega plans were the targets. And then there was a lawsuit filed against a plan that has about, or against a plan sponsor for a plan that has about $9 million in it. And there was another for a $22 million plan. So what we're seeing here is because the plaintiffs have been successful with the big plans, they can really just duplicate that litigation. And when they do that, they can more efficiently go after smaller plans. So I think they're seeing some of the low-hanging fruit out there and saying, you know, we can go after smaller plans and still make some money. So, you know, I think that's a trend that we'll see continue here for a while.
And definitely good information for our audience. All right, well, I think it's 3 o'clock, so thank you everyone for joining us. Again, thank you, Matthew, for an excellent presentation. We hope to see everybody next year at one of the 2017 conferences, and we're thrilled to say Matthew will be joining us with QPA at many of those locations. So thank you, QPA, and hope everyone has a great afternoon.
The